Welcome to today's Explainer. Okay, we've got a legal story today that honestly sounds like it was ripped straight from a sitcom, but it is actually a very real, highly unusual 2024 intellectual property clash out of the Delhi High Court. On one side, we have the global sportswear giant Adidas. On the other side, an Indian textile businessman. And stuck right in the middle, honestly one of the most creative, utterly bewildering trademark defenses you will ever come across.
So, how exactly does a global sportswear brand become a tribute to an elder sister? I know, it sounds like a setup for a punchline, right? But as we're about to see, this was a perfectly straight-faced legal defense actually submitted in a court of law. It's this wild routine of linguistic gymnastics that makes this case so incredibly fascinating for anyone interested in business, law, or, just a really bizarre story.
All right, let's set the stage with Section 1, the global brand dispute.
We are looking at a classic David versus Goliath situation here. On one side, you have the absolute Goliath, the plaintiff, Adidas AG. Founded back in 1948, they have massive global recognition in footwear, clothing, the whole nine yards. On the flip side, we have the defendants, Keshav H. Tulsiani and Associates. They run a textile business with a strictly local market focus. And yet, despite this massive disparity in size and industry, the defendants decided to register a business name, and that name was the exact same word, Adidas.
40. That is over 4 decades, guys. Adidas argued that they had built up more than 40 years of massive, hard-earned goodwill and distinctiveness. They contended that allowing a local textile business to use their exact name put all of those decades of brand reputation at severe risk of dilution. To Adidas, this wasn't just some random coincidence, it was a direct threat to their global identity. Let's move right along to Section 2, the sisterly love defense.
Now here is where things get really wild. The defendant offered up this, frankly fascinating etymological breakdown. They claim that in the Sindhi language, the word adi translates to elder sister, and the word das means devotee, someone who is deeply fond of or admires someone else. So according to them, by combining the two, you get Adidas, literally meaning a devotee of the elder sister. The defendant argued this was a completely bona fide, honest adoption. They insisted they weren't trying to steal corporate goodwill. They were simply showcasing deep familial devotion.
Spicy IP actually did a great analysis on this case, and I literally have to quote this line. The defendant claimed that the use of the trademark Adidas was done out of love and affection for his sister. I mean, it is genuinely astonishing to see familial affection used as a shield against a multi-billion-dollar trademark infringement claim. The sheer audacity of arguing that you just miraculously stumbled into the exact name of a global sports brand purely out of sibling love, well, that's what makes this case a total standout.
Okay, let's get into the legal nitty-gritty. Section 3, Trademark Law Breakdown.
In these cases, the truth is usually hiding in the timeline. Let's walk through it. Adidas is founded in 1948. Then, from 1971 all the way to 1985, Adidas is proactively registering various trademarks in India. Fast forward to 1987, and the defendant registers the Adidas mark for textiles, claiming prior use because Adidas didn't officially enter the Indian domestic market until 1989. So the defendant tried to argue that their 1987 registration predated Adidas's official 1989 market entry. They were conveniently ignoring the fact that Adidas had already been securing its legal rights in India for well over a decade before that.
So here is where the two sides completely collide. The plaintiff, Adidas, is claiming prior use, massive financial investment in brand building, and a really high likelihood of consumer confusion. The defendant counters with their bona fide sisterly adoption story, arguing they operate in a completely distinct textile market. They even went so far as to try and claim the word was a generic industry term. They essentially argued that someone buying a piece of textile wouldn't confuse it with sports shoes.
And that brings us to a huge legal concept, the likelihood of confusion. I want you to apply this test to your own shopping habits right now. If you walked into a store and bought a roll of textile named Adidas, who would you instinctively assume manufactured it, or at the very least endorsed it? The law recognizes that really strong trademarks transcend their specific product categories. Consumer perception is everything, and a famous mark carries a heavy presumption that the original brand is somehow involved.
Which brings us to the resolution. Section 4, the court's verdict.
When you look at the paperwork, the sheer volume of Adidas's multi-class prior registrations just completely buries the defendant's argument. Look at the breadth of this. We're talking Class 18 for bags, Class 25 for sports clothing, Class 29 for balls, Class 3 for goods in general.
Against this absolute mountain of established intellectual property, the defendant had a single solitary claim in Class 24 for textile goods. And actually, scratch that. That registration was actually canceled back in 2018. So the documentary evidence heavily favored the plaintiff way before that sibling love argument was even considered.
So the Delhi High Court weighed in, and here's what they found. First, Adidas firmly established prior use and registration. Second, the marks are identically and deceptively similar. Third, and this is really the nail in the coffin, despite the clever etymology, the defendant provided absolutely zero substantive proof of the sister motivation. No letters, no early branding sketches, literally nothing to prove it wasn't just an afterthought. Consequently, the court immediately granted an interim injunction in favor of Adidas, meaning the textile business was legally ordered to halt their use of the name right away.
Let's zoom out a bit for our final takeaways. Section 5. Protecting intellectual property.
There's a really great concluding thought from the spicy IP analysis that I want to share. Submissions before the court must be founded in some fundamental and indispensable logic driving them. This really hammers home the ultimate lesson of our explainer today. In intellectual property law, highly creative stories and clever linguistic coincidences, they can never, ever replace hard evidence, documented timelines, and established corporate goodwill. The courts will always look past a good story to find the documented truth.
So I'll leave you with this. In an age of absolute hyper-competition, is your brand's identity truly secure? The Adidas case proves that even global titans have to constantly monitor and defend their trademarks from the most unexpected and, frankly, creative local challenges. Constant vigilance really is the only way to protect intellectual property. Thanks so much for joining me to unpack this fascinating explainer, and keep learning.